Okay, you're good.
Well, welcome everybody. I am Sherry Lenoff. I am a client service manager for RES. My territory is Nebraska, Kansas, South Dakota, and Missouri. I apologize for having technical difficulties with my camera, but today we're going to have the exciting topic of life of a claim. So um, I'll have Therese switch the page for me. Okay, today we're going to talk about when an injury occurs, reporting a claim, employer's responsibility of reporting that claim, and the claim investigation that will go on, and then whether we accept it, deny benefits, and then our return to work plan developed and when the claim is closed. So that's basically the life of a claim right there. But before we get to that, I'll have Therese turn to the next page. There is a information that we want to go through before that because what the life of the claim starts before a claim ever is filed. So there's some things that we can do to prevent claims from developing or from making them as expensive as they can be. So one of the biggest things is just having a safety culture. If we can have a safety culture in place, employees know that there is, you care, that you're working on safety, you're wanting to make it a safe place. That makes a difference. Having a policy in place for reporting claims, so there's no question on how to report a claim, that improves the life of a claim. Um, Providing medical treatment in states if you can direct medical care. So having a physician in place if you can direct that care, maybe an occupational medicine or an urgent care that you work with. But even if you can't direct care, some people don't have family physicians or maybe can't get in. Having other options for them, like I said, an urgent care, an occupational therapy clinic, having that available, even if you can't direct care, just to let them know that that's an option for them, that can be helpful too. So having those things in place beforehand makes a difference. So return to work culture, having the culture that people know whether they're injured or whether they're going to be able to come back to work, having that culture that people know you're going to find something for them to do, and that if they're injured on the job, it won't mean that they get to stay home, that they're going to have work for them at your employment. So, and then just communication. You're going to see that throughout this whole presentation. Communication really is the key. So, according to the National Safety Council, poor communication is a contributing factor to nearly 70% of workplace incidents. Now, that can be that you didn't communicate a safety program, or maybe that you didn't make them aware of a training, something that may be a part of all of that. But having that safety culture in place, having a safe environment for employees to share whether they see concerns or their thoughts, how to make things safer, making them be a part of that safety culture helps before a claim ever happens. So next, a new claim comes in. We hope these don't happen, but we all know that they do. I guess it also keeps job security for me, but when a new claim comes in, injured worker reports the claim timely. Your responsibility is to forward all the information to us, which includes videos, pictures, witness statements, all of that information. If you can save that, preserve that information right from the start. A lot of times with videos, we get great information with that, but we know that there's a time limit of when people can actually retain those and keep that information. So if you have any video at all, keep that video, save it for us, send it to us. It makes a huge difference. Sometimes it doesn't even matter for us. Maybe we think it looks like it happened the way it did, but there's been occasion or two where we sent that information off to a physician, and they've told us that what they saw in the video, the mechanism of injury couldn't have occurred that way. Or the video also shows us that it happened and they fell and you can really see how it fell, and you really can see that that injury took place and know exactly how that fall occurred and kind of where the impacted piece of the injury was. And then from us, you'll see us have a 3-point contact. We're going to reach out to you, we're going to reach out to the injured worker, and we're going to reach out to the medical provider. And I will say sometimes people who file the claims wonder, why are we reaching out to you again when you're the ones who filed the claim? But we do that because we want to make sure there's no additional information and make sure that we're just getting everything as clear as possible right from the start. Next slide. Why is it important to report claims timely to us? It's really the impact of reporting delays. It shows here. If there's a 1 week delay, we have 8% higher costs. 2 week delay, 30%, on and on. But when you see that 51% higher costs when a claim isn't reported within 1 month, you can really see where that changes the outcome of what you're paying. And so when we're looking at lag time, which was what we call it, when we're looking at the lag time and we say, you may have concerns or your lag time's great or your lag time could improve. These are the reasons why we're presenting that to you, is because you can see what that does to the cost of a claim. Next slide. Why is it important to report claims timely? Well, we're hitting on this already, but increased litigation costs when we don't report a claim timely. It's harder for us to investigate. We have been told by judges that really the information we get initially from a claim, which is the initial medical report, the initial information they give to you, the initial recorded statement that we take, although that information has a lot of impact on them because it's really the true facts. It's what happened initially. There isn't any clouding of that information. It's truly what really happened at the very beginning. So judges put a lot of weight in that. So reporting that timely to us makes a difference. Um, kind of this increased indirect cost, administrative costs, all those are much higher. So if you don't report a claim to us timely, you're still dealing with an injured worker. You're still dealing with maybe a supervisor filling in. Maybe there's additional things that they're dealing with. All of those things play a factor of what we're dealing with. So it may be a supervisor's covering for them, another employee's covering for them. You'll see maybe lost time. It could be overtime that an employee is having to deal with, lost productivity because they're not working at full capacity. All those things play a factor into why it's important to report a claim timely. I also want to say one of the things when we talk about that 51% increase, if it's not reported in the first month, a lot of times we'll see insureds ask us if they can just pay for a claim or can they cover a claim. Or sometimes they're just covering that claim without asking and they're just doing it. Um, some of the things that you're missing by not reporting the claim or covering the claim or paying the claim yourself is that you're not getting bill review reductions or reasonable and customary fee schedule reductions, but also you're missing that investigation piece, and it puts us behind the eight ball when a claim isn't reported to us immediately. And maybe you're trying to handle it on your own on the insured side of things, because we still have to investigate. It just delays everything. And then we've lost that communication piece too, where they feel like we're not communicating as well with them. So, all important reasons why we want to make sure we're reporting claims timely. Next slide. We at RAS have three different types of claims. We have incident only claims where it's just no treatment. They just are reported a claim to you. We love that you report those to us. We want that for tracking mechanisms that we can make sure we are sending out the proper documentation. Medical only claims are medical claims that have no lost time. Minor medical, so maybe you've gotten a scratch or a bite, you've treated medically, or it could even just be that it's a more significant, maybe a burn that you're receiving medical treatment, but you're able to continue working. Then we have indemnity claims is what we call them. And this kind of we want to make sure you understand that the indemnity claims are handled by the most experienced longevity of our adjusters, the ones who have the most experience handling claims, handle those for you. They may handle a medical claim with no indemnity, but it's got a serious component. Maybe it's a, a hernia claim. Maybe that can stay medical. They're still able to work, but it's got a more serious component. Maybe it's surgical, but not indemnity. So those claims could be handled by our indemnity claims team. But I wanted to just let you know that even though it's handled by the indemnity claims team for RES, which is what our teams are, a medical only claim is still reported to NCCI as just a medical only claim, whether it's handled by the medical team or the indemnity team. But our indemnity claims are handled are where we are paying out indemnity and PPD, TTD, TPD, all of those things. So next slide. 40 to 60% of all claims that are reported are incident onlys. And once again, I said those are like our first aid claims. So it's the highest percentage number of your claims that are turned in are usually your incident onlys. Next slide. Incident only claims, first aid claims are important to report, and we've got it in here. Why? It's so we can get statutes running. So we can get those claims reported, statutes running, and get all of that in place. Um, Hopefully it doesn't happen, but on occasion, a person comes in and tells you they maybe strained their knee and it's just an incident only, they're not going to treat. Um, Usually that's great and that's what happens, but maybe 6 months from now, um, things have turned with the employment. Maybe they're not as happy with the employment or they're looking elsewhere, things like that. Then all of a sudden, maybe that situation that happened 6 months ago can become a bigger issue. And if you don't report those and we don't get the statute running, that makes a change in what the outcome of that claim could be. So for what we do, as the injured worker, we're asking them to report the incident, notify RES if they treat. For you as the insured, we're asking a couple things. Follow up with that injured worker. Are they still doing great? Document that conversation. So even though they're not treating, they say it's no big deal, still follow up with them like a week later and just make sure they're still having that same outcome. Document that. That can change the outcome for us. The other thing for RES piece of it is we're going to make sure that we send out a letter to them, an overnight letter letter that we send out to them to tell them that if you treat, if you have issues, if there's anything like that, please let us know. And we will then file the necessary documents. Also, those incident only claims for RES, we close them overnight. We send out the letter, it closes overnight. Has very limited impact on you. Next slide. Medical only claims. We are asking the injured worker to just keep us informed, tell us what's happening. We'll, fill out the medical authorization we send out. Just keep us informed is really what we're asking for them. Tell us what happened at an appointment. For an insured, just keep us informed of whether they're still working. If there's anything that's changed, we try to stay in communication with the injured worker, but sometimes they come to you instead of us regarding a work note. Just keep us informed too if something like that has been brought to you. And then just provide any documentations that we need that we're asking for. Once again, on all claims, but medical only claims too, we'll do the 3-point contact, complete the necessary investigations. So it's maybe in a recorded statement, talking to a witness, whatever we need to do for that investigation. And then just the medical strategy to make sure that we are staying on top of it, see what normally happens, and make sure we're kind of following that same pattern. We're going to pay the bills timely, and then we're going to try to get that injured worker to MMI as soon as possible. And MMI is maximum medical improvement. And just to mention that too, maximum medical improvement doesn't mean that they're 100% better. It's just that at this point, medically, that's the best they're going to be from this outcome. So it doesn't mean that they are at the final outcome or they may not still treatment, but it's where their maximum medical improvement is going to occur. Next slide. So then we have indemnity claims. These are the more complex ones, and they're going to have a longer tail to them, so they're going to be in our lives a little longer. Provide status updates after each appointment. That's what we're wanting the injured worker to do. Review restrictions with us and with you. And once again, just keep that return to work policy in place for our insureds. Keep making sure that they're following and you've got a policy in place, and stay in communication with the injured worker regarding the work status, and then forward all necessary documentation. Similar to the medical side of things, we're going to stay in contact with you, injured worker, medical providers throughout the life of the claim. But also, we're going to be looking at other things regarding optimizing the treatment, maybe looking at independent medical evaluations if needed, authorizing those medical referrals. Maybe it's doing a surveillance if we feel that there's some things that we need to do a little deeper dive into. We can do investigations in like their social media history, things like that. Maybe that's important. We're going to continue to pay bills, lost time wages, and try to get them to that maximum medical improvement again. Next slide. And then just some other considerations that we have to look at. Litigation has a significant cost increase. It tells you, once again, it gives you the importance of reporting claims to us timely. It makes a difference on those costs with that too. But you can see how legal involvement adds to the cost of a claim. And if we can prevent that by communicating and staying in communication with them, reporting the claims timely, makes a huge difference in the outcome of that claim. So when they talk about the average duration of a claim with an attorney, 471 days more than non-litigated claims, according to that study. That's a huge number. And that's really why we want to keep people back to work so they're not at home during that 10 to 2 time frame when you get all those um, legal commercials out there. So if you're watching Young and the Restless or whatever, you'll see all those commercials from work comp attorneys. That's what we want to keep them back to work so they're not seeing all that. And we can keep them away from the litigated costs. But if the file does become litigated, we cannot have any further communication with the injured worker. We're only going to talk to the attorney. And for you, as the insurer, or the insured, we want you to make sure that you're only talking to them also regarding the work status piece of it and their and work there, and not the outcomes or the type of claim and what's happening with the claim. Just to keep it just to their work status and that information when you're communicating with them too. And if it does become litigated and you get notification, send all of that to us. We respond to those legal requests and we respond to that for you so you don't have to. And then one more slide. Um, Medical case management. We use case management on claims for that life of the claim. It may be they may attend medical appointments, and it is a piece to help communicate with all parties. Case management that we add isn't just for our benefit or for your benefit, it's also for the injured worker's benefit. If you go to an orthopedic or you go to medical physicians, sometimes they don't always give you a lot of time to ask questions or give you that, um, time to come up with a question even. The case nurse can help them with that. But it does help us get timely information, so we can get a return to work note quicker and get the medical records faster, or at least know what was discussed at those appointments. And case management, we have basically three main types of case management that we use. Field case management, which means they're going out to the appointment. We have telephone case management where they're following up with the doctor and the injured worker. And then we just have a task assignment. Maybe it's at an end of a claim and we just want them to go and get them, the return to work note or see if they're at MMI. And a task assignment may be done if you feel like you have work available, but we're not getting that medical return to work note from the physician. We may use the task assignment case management for that to help us with that. And then the other consideration we have in a life of a claim is a subrogation. We look for any negligence in a third party, and that you can help us out with by looking at where the injury occurred, just keeping all that information. If there was a piece of equipment that was involved, just save that, retain it. If there's something wrong with it, don't fix it. Give us a chance to see if we need our subrogation experts to go out and take a look at it. to preserve our rights for subrogation. Because if you make any changes to it, modifications, it does not help us when we're trying to collect on a third party negligence case. So those are other considerations that we need to have. Next slide is really what we're looking for is just communication. The claims process works when we all work together. And I truly believe the communication piece with all of us is important. If you feel like you're missing a piece of the communication from us or from the injured worker, let's have a conversation about that and let's talk about it because we want to make sure that we're all communicating together. It really needs to be a team effort for the claims process to work well. And that's where I think working with the injured worker, you and RES just makes the claim go smoother. And our outcomes are much better than when you saw those initial increased costs from a claim that's started off poorly and maybe we can't get it back on track right. So that is my presentation. I know we go through them fast here, so we're just keeping you at the 30 minutes, but do we have questions? Is there
We
anything?
do. We do.
Okay.
I do want to point out one thing. When you say TPD, you rattled a bunch of little
Yep, yep.
acronyms off. Can you just clarify what they are for those? And then I'll read you the questions.
Okay. I'm going to give you a quick next month. It is acronyms is what the presentation is. So you'll have a couple of my counterparts presenting on that. But temporary total disability, or what we call TTD, that's when somebody is temporarily totally disabled and cannot work. So we're going to pay them their full lost wages based on the 2/3 and the state maximum. Temporary partial disability is they're partially able, so maybe they can work 4 hours a day, but they can't work their full hours, and we compensate that difference. And then permanent partial disability is when they receive an impairment rating or there's disability based on that injury. So each state gives guidelines on how many weeks a finger would be, or an elbow, or a knee, or a body as a whole claim. And so we pay benefits based on that.
Okay. Okay, I have a few here. This is
Okay.
a longer question.
Okay.
Can you clarify as the employer why we are unable to obtain medical records or return to work records from RAS? I understand that the employee needs to release that right, but would like to have them release the right to both RAS and the company.
There's a couple reasons why we look at that a little differently. One is I know we talk about HIPAA and HIPAA regarding work comp. There's some rules that HIPAA doesn't apply to work comp. But when you have those medical records, there's a lot of other things that are in those medical records that are very personal. And so it, it just causes more issues when you can see everything in somebody's medical records, and it makes the injured worker a lot of times more uncomfortable. And we want to get those signed medical authorizations so we can get prior medical and we can get all that information. And if they feel that we're sharing that with everyone and sharing that history, especially with the insureds, that it makes it even more difficult for us to get that information. So we try to share with you all the information regarding the specific injury and what it tells you. And if you go into our claims enterprise, a lot of times there'll be a very good overview of what that medical note states. Um, but it is really just more for the privacy of the injured worker on what other pieces of information in there, because in a medical note, there's a lot of extra personal information that is not related to the specific claim. And it has nothing to do with what the claim involvement is. And so that's why we try to limit that, just because of their personal history that's in, even if it's a work comp claim, a doctor always gets all of their personal history. Now, if it affects the claim for some reason, we can let you know that information, but there's a lot in there.
Thank you. All right, number two. If RAS decides to do things like surveillance, is that shared with the employer?
I will say usually. Um, Usually we do, because we want to get some of that maybe description of that injured worker and some of those things from you. But I can say there are times when we don't get that information because um, it can be the relationship you have with them. It could be there can be reasons why we don't, but usually it is something that we will have a conversation with you about. Because usually you help us know when we need to do surveillance because you may have the suspicion that they're doing something else. Maybe you've heard that they're roofing their house or they're moving over the weekend or they've been doing sprint car racing. Usually when we know that there's something more out there, it's because of somebody who's come to you or and then you come to us. So usually you know about the surveillance. I will not tell you 100% of the time we're going to tell you about the surveillance, but usually you will know because we'll have that conversation with you if you're aware of anything else that they're doing. Um, so usually you're going to know.
Okay. Is there any penalty in reporting incident only claims? My employer thinks that if there are a lot of incidents, it will change the work comp coverage. Um,
Yeah. Some of this I'm going to give you because I'm a claims person, so I'm going to give you the claims information on that, but you can also verify with your agent. I want to give the shout out to them too because they are part of this communication piece.
mhm.
But if you even if you have a medical only claim, a medical only claim where we're paying no indemnity through the NCCI or the bureau that most states use for how we connect and pay premiums and how you're rated and that you get a 70% discount if it's a medical only. And if we pay nothing, that has no adverse effect regarding um, the your score, your rating through NCCI. So if we haven't paid anything, it's not affecting you in those ways. That's how we want to encourage you to report those. So we're documenting that and getting that on the books for statute purposes, but it's not affecting you regarding your NCCI rating or your mod rate is what they call it in most states. I know there's some states that don't use the mod rate, but it still doesn't have the effect that it would just because we're not paying anything. So,
And there's another part of that question, and I don't want to get too into detail because
yeah,
I don't. Um, so if an employer would choose to pay out of pocket, I know that there's a Missouri that has certain rules for that.
correct.
They can't, but there are employers that do that. Is that correct? Beyond Missouri?
Um, we do not want anybody paying out a claim on their own. Missouri has an employer paid situation where they have to notify us. It's a part of the statute where if they want to pay a claim on their own up to a certain dollar amount, and as long as it's not lost time, they can do so, but they need to let us know. Otherwise, if you're paying a claim on your own, I'm going to see that what we see happen, and we don't always know if you've done that because we're not given any indication of that. When we find out about it is when it goes south. And when they go south, it's going south really fast. Um, an example could be that you haven't turned in a claim, you're paying the bills. You're not getting fee schedule reductions, you're not getting reasonable and customary. And if you can direct care, you're not able to do that because we're not in control of that. We don't get any of the details of what happened initially. And then when it comes time that somebody needs to have surgery, so it's gone further and they need to have surgery. Well, we have to do a full investigation and we can't authorize that surgery. So now the injured worker is upset. You're probably upset because we're not authorizing it and as the insured, but we've got to investigate. We've got to get all the prior medical that has been occurred, maybe even prior medical to the incident. All of that takes a whole lot more time when that when we're playing catch up. And that just delays a claim and the outcome is. And if you look at the savings you're getting by fee schedules or reasonable and customary and how much we can reduce those bills, and you're looking at the percent of savings that you're getting, when it's only 30% of that claim is affecting your mod, If you are paying out medical, you have to really look at, are you really getting any benefit by paying that yourself? Because I think in a lot of ways you're going to find out with all of that, you're not. That's a really good deep dive question for your agency to go back and talk to them about. Once again, I'm a claims person. I'm wanting you to turn those in, but I'm telling you that on a side note, I feel like it's not this, you're not getting the benefit you think you are by paying those out yourself. So my personal opinion, which I'm probably not supposed to give in a presentation, but
I would consider that a best practice.
yes, yes,
How's that?
perfect.
Okay. Here's another question. When the initial call is made and the employee is speaking with RES claim staff member, must the employee leave or best practice to provide privacy for the employer? I think they mean is the if the employer is there with when they're talking to you guys on claims, should the and they might be speaking of personal medical information, should the employer be in the room or should they leave?
I mean, I would say that that would be just a policy that you have in place. I don't think other than because we do have to get the social security number, which as an employer you probably already have. Um, we're not going to ask you. We do ask a little bit, like, some medical things. If they're if they choose, if they're uncomfortable, they won't have to answer that. But also just more of those details on that. I just think you're probably okay not being in the room, or you're okay being in the room. If they're uncomfortable giving you that information, they certainly don't have to share that with you. So I'm not as concerned about that because we're not asking as many detail. We're asking more specific claims, what happened details at that point, and not so much personal background information.
Mhm. If you're reporting like to like reporting the claim initially and there's you know personal health information comes up, you know it would be common courtesy maybe to walk away as the employer, just let them have that moment of that, but we
Yeah,
don't have rules on that.
right.
So um then I have, will you be sending a slideshow to us by email? We usually put that on the portal, so in the featured content on the portal is where we put the slides at the end of this. If there is a specific request, um, let me see. Did we put your slide at the end, Sherry? Yes. If you
Yes.
get a specific request for the slides, would you just email us and I will make sure you get them? Okay. In case you wouldn't have portal access, we want to make sure you have the portal access and you maybe don't if you are not with us that way. Um, I see we have one hand raised, and it's Micah. And I'm going to allow you to talk, Micah, in case you have a question and you didn't want to put it in or you didn't have it in the questions online. So I'll push the allow to talk button quick.
Well, I think I might have just accidentally raised the
Okay.
button.
That's
Sorry
okay.
about
I
that.
didn't know. It's okay. I didn't want to feel like you couldn't speak if you needed to. And I see we have Vicky with another raised hand, and I'm going to do the same for her a minute. And I think that she disappeared. That's
Maybe it's
okay.
raising hands like, thank goodness it's over. I don't know.
Maybe. Anyway, if you have any other questions, feel free to reach out. Those were the ones that came in. Thank you. I know we're over, but it was more questions than it was anything else. But thank you again for that. And feel free if you have specific claim questions, um, go ahead and reach out to the claim rep. And if you need help on figuring out who that is, we can assist you on my end. There will be a survey when I end this, and you feel free to go ahead and use that. We also look forward to you for the next coming webinar, as Sherry mentioned. The next one is all of the acronyms that we use in work comp and how confusing that is, and might help with some of you with all those questions on what those all mean. So thank you for attending today, and we look forward to seeing you again. Have a
Thanks,
great day.
everyone.